Good morning, Mr. Chapman.
Good morning, Your Honor.
How are you today?
Doing well, thanks.
Good. You can proceed when you're ready.
Thank you. Before the court is Lewis. Mr. New is here today after failing to appear before this court on June 22nd, 2022. Bond is currently set at $2,395. This is the fourth bench warrant. He reports that he is employed by the city of Detroit. Last payment made on this account was in November of 2023, and that was from the city of Detroit through income withholding. Front of the court requests that a reasonable bond be set on this matter and it be scheduled for hearing on January 24th, 2024 at 8:45 a.m. before this court.
Mr. New, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your tenants at the next hearing on January 24th, 2024 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Not right now because I'm not in Detroit. I'm not from here. And my family, the only way I get home is through Greyhound. You know what I'm saying? But I also have wrote a letter to FOC, and I also contacted FOC in November that I had got shot and that I wasn't able to work. I also sent doctors excuses, and I also sent a letter from my job.
Okay. Are you working now, sir, or you're not?
Yes, I'm they have me right now on temporary hold because I'm still nursing my wound. I'm supposed to start back this month on the 24th. And I also was getting a crime victims compensation check that it was supposed to be here maybe next week because I'm incapacitated. Like I've been getting care inside the jail. I have an open wound in my leg.
Okay.
I just got October 16th and I had surgery December the 2nd.
Okay.
But I have been paying, like you can see, the last payment was in November. You know, I make sure I call you guys all the time when I get a job and let you guys know, hey, I'm working. This is where I'm working at. You come out and take your money. I do it every time.
Okay. Well, the court does note, obviously you have a sizable arrearage in this matter, but the court will take note of your circumstances. What I'm going to do, sir, is I'm going to set a zero bond, which means you don't have to post any money, okay?
Okay.
And you'll be able to get out today, but it's still going to take a little bit for the paperwork to catch up. Probably be an hour or so before that can happen. And what happens, you're going to need to contact your enforcement worker prior to the January 24th date to see if you can't work out something with them. Okay?
Okay.
And if you can, then you wouldn't have to appear, but otherwise, if you don't work anything else, you will need to appear on that date.
So work out something, meaning just I can send them maybe $400 or $500, and then that'll work out because I start work back on the 24th.
Yeah. Check with your enforcement worker, and you can work something out with them. Okay.
Okay. Thank you, Mr. Kirkham.
Okay. Thank you. You have a good day.
You too.
Mr. Ruck is here today after failing to appear before this court on August 2nd, 2023. Bond is currently set at $24,903. This is the seventh bench warrant. He reports that he is employed by tree service. Last payment made on this account was in May of 2023. Front of the court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on January 24th, 2024 at 8:00 a.m. before this court.
Mr. Ruck, in this matter, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your tenants at the next hearing on January 24, 2024 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, sir.
Okay. Well, obviously you have a sizable arrearage in this matter, and you do have 7 prior bench warrants. What I'm going to do is I am going to reduce your bond in hopes that you'd be able to be released. I'm going to set your bond in the amount of $1,000. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir. Well, what happens if I can't post it?
Then you'll stay there until the hearing on the 24th.
What happens then?
I don't know. We'll have a hearing on that date and then we'll work out what happens at that time.
Okay.
Okay, thank you, sir. You're free to go. Have a good day.
At 9:01 a.m.
Court will note the appearance of Mr. Todd on behalf of plaintiff, Ms. Podolsky on behalf of defendant. This matter is before the court on the plaintiff's motion for contempt, and the defendant has filed an answer. You did receive the answer, Mr. Todd?
I have, Your Honor.
Okay. Anything else that you'd like to add, Mr. Todd?
Your Honor, I will largely rely upon my motion, but even since we filed this motion, there have been substantial issues. On December 24th, Mr. Aldrich gave my client a gift, which was a heart stating "to my wife." The card attached, or the box attached, stated "to honey buns from I will," and there was a poem inside of this gift. Additionally, there have been consistent messages outside of our family wizard and outside of the scope of relating to the child. For example, there were substantial messages on January 9th about Mr. Aldrich's Bible study and asking why my client is ripping the family apart. We have tried to resolve this peacefully and tried to prevent it from going to this point, but I don't think this is just not resolving itself. So we are respectfully requesting he be held in contempt. We're respectfully requesting attorney fees for having to file this motion.
Okay. Ms. Podolsky.
Thank you, Your Honor. As we've stated in our response, the plaintiff in this matter is not telling the court the complete truth. She often initiates these conversations. They are often not about the child. They have been about mediation, resolving issues. And when conversations break down, she's not getting what she wants, then she files a motion for contempt and does not include her part in these conversations. I liken it to the behavior in a PPO. You can't get a PPO against somebody and then initiate that contact and ask that the PPO be violated. That's exactly what's happening here. She's calling, she's texting, she's using our family wizard, but not including those sides of the conversations in her motion. We mediate this case on Thursday. We have repeatedly asked for co-parenting counseling so these parties can get on the same page with parenting their minor child. This is a family with deep spiritual roots. They are trying to guide their child spiritually in her religion through this very difficult time. My client has simply been trying to explain to the plaintiff what he's trying to do as a parent, how he's been feeling, how his brain works in these conversations when she gets angry with him because she's not getting what she wants. And then when he tries to explain this to her, she gets upset and files this motion. We do not believe that there should be any sort of contempt because this is just simply two people who are unfortunately going through a divorce. They're trying to navigate this process, having not done it before. And this is just simply not a case for contempt here, especially with plaintiff's actions not telling the court the complete truth. So we're asking the court to deny the request in its entirety, award costs and attorney fees, and we'll proceed forward with mediation on Thursday.
Well, looks like you need to proceed on mediation on Thursday, but court does note that it does appear that there are disputed issues in this particular case that need to be addressed and to be, again, flushed out at that particular time. So we'll contact both of the offices and set a time for a hearing in this particular matter if you're not able to resolve things at mediation. Okay.
Yep.
Anything else, Mr. Todd?
Your Honor, do you need me to prepare an order, or will the court just set that?
No, we'll just set the matter for a hearing and be in touch with both of you.
Okay. Thank you, Your Honor.
Okay. Thank you. Have a good day.
At
You as well.
9:07 a.m.
Court will note the appearance of Mr. Fernandez on behalf of plaintiff and Ms. Capture on behalf of defendant. This matter is before the court on the defendant's motion to compel plaintiff to reinstate defendant's health insurance. Ms. Capture.
Hi, thank you, Judge. As is noted in our motion, as well in our response to plaintiff's response to our motion, that we had already previously requested that defendant or plaintiff not remove defendant from his insurance and to continue to maintain the status quo. That message was sent to plaintiff's attorney on November 3rd. We did communicate directly with plaintiff's attorney to confirm that they did receive that. Ms. Sharp did state that she did receive it. Despite that, plaintiff continued and removed defendant from his insurance. Defendant is currently unemployed. Even if she were employed, it would be difficult for her to obtain employer-based insurance. We believe she cannot qualify for Medicaid given her current marital status. This is why it is commonplace and common practice that parties during the pendency of a divorce maintain health insurance the way it is maintained, maintain that status quo. Because of that, defendant is suffering costs for her prescriptions. She has a pre-existing condition. She has had multiple appointments with her doctor regarding an upcoming surgery that is likely to occur. We are asking the court now to require that plaintiff reinstate the insurance. We're also asking, Your Honor, because we had communicated effectively with plaintiff and he ignored us, we're asking that he reimburse defendant for any unnecessary out-of-pocket expenses regarding her prescriptions and pay attorney fees in the amount of $800 for having to bring this motion before the court. Thank you.
Okay, thank you. Mr. Fernandez?
Yes, Your Honor, it's difficult for me to speak to communications between Attorney Sharp and opposing counsel. I believe that she likely relayed it to our client. However, that was around the time that he did take her off his insurance. He admits to doing that. Their child is still covered on that insurance by taking her off in November, and he let her know at that time he believed that she would be able to attain some sort of Medicaid or marketplace coverage, Your Honor. And he has contacted his employer since then, but I have a screenshot of the email from their benefits specialist saying that he will have to wait until the next open enrollment period now. So it would be difficult at this time for him to re-enroll her on his insurance, if not impossible. We would ask that you deny the request for attorney's fees. And at this time, you know, we can't really move forward with a new enrollment back onto his plan, unfortunately.
You know when the next enrollment period will be?
First of the year.
The first of this past year?
It would be next year.
Okay, next year.
Well, what the court's going to do in this matter is I am going to order that the plaintiff, we'll strike that, that the plaintiff would re-enroll defendant on the healthcare insurance and would do so forthwith. I know that, again, that might be difficult because of the open enrollment and, again, those particular provisions, but I will order that he reinstate or acquire other insurance for her forthwith in this particular matter. And what the court will do is, until such time as she has acquired that insurance, the court's going to order that he be responsible for any healthcare insurance or other cost that she may incur in the interim in this particular matter until such time as she has coverage. So, Ms. Capture, you can prepare the order to that extent and submit under 7 day. I'm not going to order attorney fees at this particular time, and but that will be the order of the court, and we'll proceed that way. And then I'm sure we're going to have to address this matter again, because I don't know what's going to happen as it relates to those other expenses, although that's why I ordered that, in fact, he would be responsible for reimbursing her any of those particular healthcare costs in the interim until she is re-enrolled.
Thank you, Your Honor.
And thank you. Free to go. Have a good day.
9:24
You as well.
At 9:14 a.m.
Court will note that this is matters before the court on the defendant's motion to show cause in this particular matter. Mr. Sanford, I do note that, I think as you say, we do have on, February 21st at 1:30, there's an evidentiary hearing on other issues in this matter concerning, contempt, et cetera. So I guess the court would simply, feel it's probably more expedient to put this over and have the whole matter heard at that time. What are your thoughts?
Your Honor, that's why I brought it. I just wanted to make sure that when we came on the 21st, we weren't just addressing the issue of the monetary and rather all of our issues together. So I really just wanted to make sure they were properly before the court.
Okay. What the court will do is the court will hear those matters on the February 21st date. I will have you, if you would, do an order simply setting the matters for that date as well, so that there's a notice to the plaintiff.
Okay, thank you very much.
Thank you.
6 a.m.
Court will note the appearance of Mr. Zubik on behalf of the plaintiff, Mr. Todd on behalf of defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time, support, and exclusive use. Mr. Zubik. You're muted, sir.
My apologies. Thank
Okay.
you. Good morning, Your Honor, and opposing
Good morning.
counsel. Sure, you've had a look at the motion here before you, but just to summarize, she's okay with joint legal custody. She is seeking sole physical custody for the minor children, and this is because she's the one who's working. Gregory hasn't worked since 2016. He's on Social Security disability. He hasn't taken any initiative to see the children since their separation. He's had lots of opportunities afforded to him by Mrs. Edwards, even at the marital home, to use the marital home to see the children, and he's passed up on these opportunities. Her sole physical custody also goes into the exclusive use of the marital home, which she's seeking. And this is, I think, for the best interest of the children to kind of be able to keep as much normalcy in the course of these proceedings as possible. This is a house that children know. And further, with the defendant Gregory, she does want him to still be involved in the children's lives. She's willing to afford parenting time again to try to keep a sense of normalcy throughout the course of these proceedings for the children's benefit. And she'd be willing to do that as outlined in the motion for the Mondays, half days, alternating holidays, alternating weekends. And further, the Social Security payments, she's not seeking child support, but she's seeking the Social Security payments that are owed to the children in lieu of the child support payments, which is actually less than what the calculator had showed. And finally, just to remove any of the devices, the tracking devices that the defendant may have placed on any of the vehicles that Mrs. Edwards has access to.
Okay, thank you. Mr. Todd?
Thank you, Your Honor. Your Honor, I will largely rely upon my answer. There was a dispute during Thanksgiving. In essence, this has to do more with the plaintiff's paramour and her new relationship. It is not accurate whatsoever that Mr. Edwards hasn't been exercising parenting time. In fact, he's seen the children almost every single day, as he is, in fact, the person who picks up the children and takes them to school. And that's actually agreed upon in their opposing counsel's pleadings in number 18. Then beyond that, additionally, Mr. Edwards has been exercising parenting time on the weekends. Miss Edwards will go and spend time with her boyfriend, and as a result of that, Mr. Edwards is taking care of the children. And he does exercise that opportunity, and he has been exercising that opportunity. Plaintiff has started a new relationship with someone by the name of Mark McKediak. This person was just released from jail recently due to possession of methamphetamine conviction. That conviction date was 2022 with an incarceration term of 1 year. Additionally, in 2022, he was incarcerated for assaulting a pregnant individual, which is the second offense. Mr. McKediak has 8 convictions on iChat for Michigan only, including felony weapons charge, as well as 3 assaultive convictions. Mr. McKediak should not be around the children whatsoever. Plaintiff is the person who has been doing all the parenting time during the weekends. Or defendant's the person who has been doing all the parenting time on the weekends, so plaintiff can be with this person. We don't know whether or not the plaintiff is engaging in drugs or anything like that, but her accounts of what happened certainly indicate that that could be an issue. The children are not safe and should not be around Mr. McKediak. We believe that this is all kind of a ploy, in essence, to hide her relationship of what is actually happening with this new person. We do believe it would make sense for the court to have an FOC investigation, as there is so much underlying issue with both the parties. We're respectfully requesting parties continue the status quo whereby the children are with plaintiff during the week and the defendant would have parenting time at the house during the weekends, and he can continue to take the children to and from school. We're requesting FOC investigation, order a psychological evaluation for both parties, and any other relief that the court deems appropriate.
Okay, thank you. Mr. Zubik, anything else?
Yes, if I could just respond to that. As to the new relationship, it is a platonic relationship. This is a friend of hers. And we do understand that he has been incarcerated for different offenses. However, he's not around the children, as the opposing counsel states. He's only ever, I think, seen them once or twice. And this was when she was around as well. It was for a very short period of time. They're not in his presence and certainly not under his care. Yes, the Gregory has been taking them to and from school, but outside of that, nothing more, even after he's been afforded the opportunity to see the children on the weekend. And as for the weekend parenting time, upon my information belief, it's just false that he's ever had them for the weekend. Further, as for the psych evaluations, or even, I guess the psych evaluations, she would be okay if, both parties would submit to that. And as for the drugs, she's not using any sort of drugs. And that's all.
Okay, thank you. Mr. Todd, anything else?
Your Honor, we would vehemently dispute that he hasn't been exercising the weekend parenting time. He has. And I mean, I guess it's kind of a he said, she said in this particular matter. But.
Okay. Well, what we're going to do on a temporary basis is the court is going to grant to the parties temporary joint legal and joint physical custody. The plaintiff would have the children during the week, and the defendant would have the children on the weekend, meaning Friday through Sunday, Friday 6 through Sunday at 6. He also have the right to continue to drop off and pick up the children from school, provide that particular service. The court will award plaintiff the Social Security payments for and on behalf of the children, and that will include any that the defendant has kept since the action was filed. So you have to go back to the filing date in this matter. Let's see what that, which looks like 12/19/2023. So any payments made after that date, he'll have to, in fact, reimburse the plaintiff those particular sums of money. That will be the amount of support, because obviously in these instances, that amount is going to probably well exceed the amount he would be required to pay pursuant to the formula. So that court will not award any additional support. Court will award the plaintiff exclusive possession of the home. Court would order that the defendant would remove any tracking devices or other software from plaintiff's vehicle or vehicles. The court would also order that Mr. McKediak would not have any contact with the children during the pendency of this case. So that will be the order. Mr. Zubik, you can prepare that order and submit it under 7-day notice of entry.
Will do. Thank you, Your Honor.
Okay.
10:34 a.m.
Thank you. Good morning to both of you. The court will note that this matter is before the court on the defendant's motion to set aside the referee recommended order. Mr. Shepard, in this matter, I do note when I reviewed the referee order, and that he states that again, that you did not appear, and obviously you're contesting the amount of income that was attributable to you. How do you anticipate, or how do you expect that the referee would know what that is if you don't appear for the hearing?
I wouldn't know if I didn't appear for the hearing.
Excuse me?
He wouldn't know, and I didn't appear for the hearing. That's why I did a motion and explained and expressed of what I did actually make compared to what they were trying to say I made.
Okay. Well, and I understand you say basically you do note in this particular matter, if you were making minimum wage, your income would have been approximately, well, it would have been $1,763 per month. If you were making income, which is basically income sufficient that, but most jobs are paying in this matter of $15 an hour, your income would be $2,580. So the referee used a number that's about in the middle of that when he in fact imputed income to you. You understand that?
Yeah. Okay. But thing is though, how can I make that much? I don't have a high school diploma and I have a felony.
Yeah.
A lot of jobs don't accept felonies anymore.
Well, I will tell you, there are a lot of jobs that are out there now where they are taking individuals that do have a felony on their record because, again, the labor market is so substantial that they need individuals. And as a result, they've basically loosened up requirements, rules, et cetera, relating to employment. So anything else that you have to offer, sir?
Like I said, I don't have a high school diploma either, which also makes it even harder to get a job. I've been with this one job for the last going on 4 years now, but $60 a week ain't cutting it. That's all I've been making because either machines are going down or there's just not enough work. And other job, I've been getting a hold of them, no reply back. I've been putting applications in and I haven't gotten no replies back from any places, not even factories as far as like Denso or Ilex or Tenneco or Gate.
Okay. Have you followed up with them, sir?
Yes, I have, and I haven't heard anything. I've even gone through U.S. Staffing.
Okay. Well, based upon what you stated and based upon what the court has seen at this point, the court does not find that the referee made either a factual or a legal error in this matter, and that's what the court has to find to be able to set aside the referee recommendation. As I stated, the referee imputed income to you in the range of what you should be able to make. I understand you're saying you haven't made that amount, but again, what happens in this matter is you're going to need to attempt to take, I guess, greater action to acquire employment. And then at that point, if you're not able to, after taking additional action, then you always have a right to file a motion at that point and ask that the court would review it. Ms. Caston, anything you'd like to say?
I just don't want child support, so I don't know if that has anything to do with this, but if we can drop that, that would be great. I know the court goes after so much, but to help him, we can drop.
Let me ask you this, Ms. Caston, are you receiving any sort of public assistance on behalf of the child as far as Medicaid, food stamps?
Yeah.
Okay, see, the court cannot cancel support if you are receiving public assistance for and on behalf of the child. So
okay.
So the court is not able to do that in this case. Okay, what the court's going to do at this point, as I stated, it does appear that the referee had made a reasoned decision based upon the information that was available, based upon what the referee had. So what happens, the court does not find a basis to set aside the referee recommendation at this time. Again, sir, if you want to take effort to try to acquire employment, and after doing so, you can file a motion. The court would review what action you've taken at that time to determine whether it's sufficient to be able to deviate from what the referee had stated. So that will be the order of the court. And
I have one question.
Yeah, go ahead.
It's saying that they want me to pay $435 a month for the child support stuff.
Okay.
Which I know for a fact because I've known Alexis for the last 6-7 years or whatever. I know when she needs to have Parker watched, it's either her mom or her grandma that watches Parker when she has to work. So there is no actual daycare that's actually taking care of Parker. So there's no really expense there other than the expense of food and diapers and stuff for Parker, which I plan on trying to help Alexis with that.
Okay. Well, let me tell you what happens, sir. When a person is working and when they are working, then the child support formula does require that the court would in fact recognize and impute childcare to that person when they're working or when they would be scheduled to be working. And so that is why the childcare would have been included in that support amount. And so the court, all the court is doing and complying with the law, which requires that the court recognize the childcare costs for the party that has custody. So that's what we're doing. And again, the referee didn't make an error when he did that because he was only following the law. So,
Gotcha.
okay.
So basically, I'm paying $435 a month right here.
Yes, yes, you're paying whatever the amount the referee had stated. And again, you can file a petition, let's say after 6 months, 9 months, if you've made some diligent attempt at employment and you're still not able to do it, the court can reassess it at that time. Okay.
Okay, so
Thank you.
basically, if I don't pay this, I go to jail.
And that's possible, correct?
If I can't afford it, so if I can only afford $20 a month, what am I supposed to do with that? That's about all I can afford right now.
Yeah. Well, all I can tell you is that there's an order and you have to comply with the order. And if not, then you'll be subject to enforcement action, which on a first offense would potentially provide that you could serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. So unfortunately, that won't happen. But I think what you need to do is you need to make some greater attempt at acquiring employment that would allow you to pay that support obligation. So thank you both. You're excused. Have a good day.
At 10:47 a.m.
Court will note the appearance of Mr. Bartel in this matter. I have had opportunity to review Mr. Bartel's answer. And Mr. Bartel, you stated in the answer that you did not receive a copy of the motion. Is that correct?
That's correct, Your Honor. I only received a notice of hearing. That was the only thing my client received. The proof of service indicates that there was a motion and notice of hearing served both on my client and myself, but that was not the case. But I see that the title of this motion is requesting to have a court-appointed attorney, so I don't believe that is appropriate or allowed. So that was part of my answer.
Okay. Well, if you might, Mr. Bartel, what happens is obviously it'd be good to have the motion. The defendant is arguing that pursuant to ICWA that she's entitled to court-appointed attorney. So, Ms. McCoy, you heard Mr. Bartel say he has not received the motion in this matter?
Yeah, I emailed it and I also sent it through the mail to Angela Davis.
Okay, you didn't send it to Mr. Bartel, correct?
Yes. Yep. It was on M-File.
Excuse me?
Which automatically goes to his email, so yeah.
Well, you can't, what happens, Ms. McCoy, you cannot serve another party by email unless they consent to be served by email. So
okay.
If you send it to Mr. Bartel and he hasn't consented to it, it's not a proper service.
Okay, yeah, because I've been also waiting to be served for the
well, what the court's going to do is
so I don't know why being served is a big deal to him, but
I do want Mr. Bartel to have an opportunity to review the motion. It's only appropriate. So what the court is going to do is I'm going to put this over until January 29th at 10:30. And what we'll do is, Ms. McCoy, you'll have to serve Mr. Bartel in the meantime with the motion in this matter, and then you'll have to do a renotice of hearing. And once you've served that on Mr. Bartel, then we can be back on the 29th and address the motion.
okay. All right.
Okay.
And to serve him, would that be through mail then or in person, or how would he like me to serve him?
You can serve him by mail.
Okay. All right. Yeah, no problem. Then I can do that.
Okay. Okay. Thank you. You're free to go. Have a good day.
All right. Thank you. You too.
Bye.